This is the Thayer Podcast for Monday, April 29th, 2024. Last Thursday, April 25th, the U.S. Supreme Court heard arguments involving 45th President Donald Trump's claim of presidential immunity from prosecution for alleged violations of both civil and criminal law. The plaintiffs charged that felony violations outside normal administrative duties are prosecutable. The president claims absolute immunity as long as he is or has been acting in an official capacity. Third parties have referred to President Trump's legal entanglements as politically driven persecution. The Supreme Court will let us know, probably before the 2024 election cycle goes into full swing this summer. Meanwhile, we can try to figure out what's right with a little research. A very informative article at findlaw.com on July 15th says, the Constitution doesn't directly discuss presidential immunity from criminal or civil lawsuits. Instead, the privilege has developed over time through the Supreme Court's interpretation of Article 2, Section 2, Clause 3. The president is absolutely immune from civil liability arising from actions relating to official duties, including acts in the outer perimeter of those duties. Immunity does not cover unofficial conduct, criminal conduct, and conduct occurring prior to entering office. The legal doctrine dates back to 1867, when the Supreme Court placed the president beyond the reach of judicial direction, except for a small class of powers that are purely ministerial. The court declared that the president was not reachable by judicial process, and it discussed the horrible consequences should the court get involved. Noting the limited meaning of the term ministerial, the court observed, very different is the duty of the president in the exercise of the power to see that the laws are faithfully executed. The duty imposed on the president is not ministerial. It is purely executive and political. Any attempt by the judicial branch of the government to enforce the performance of such duties by the president is an absurd and excessive extravagance. In other words, the Supreme Court can't just set aside the constitutional principles that forbid judicial interference in the president's exercise of executive discretion. That's because Congress is the legislative branch of the government, and the president is the executive. Neither one of them can be restrained by the judicial branch. Let's say that Congress passes a law and the president refuses to obey it. The court has no power to enforce it. On the other hand, if the president complies with the court order and refuses to execute an act of Congress, it's a clash between the executive branch and the legislature. Can the House impeach the president in this situation? If so, could the court intervene on behalf of the president, who would be in jeopardy by complying with the court's mandate, and still be restrained by the Senate acting as a court of impeachment? Would that be looked upon as the court trying to squelch impeachment proceedings in the Senate? That's a very sticky scenario. Well, we'll see soon enough what's what and what isn't. Meanwhile, improvise, adapt, overcome, simplify.